Badlands. Explain those Badlands. That's a hell of a name.
Good evening and welcome to the No Treason Podcast. This is episode 23. I am your host, Jonathan Drake. This is a pre-record, but still, thank you for joining me. I hope you enjoyed last week's marathon of No Treason Podcast, then followed by 3 straight hours of the narrative. That was definitely the longest I have ever been on stream before. That was fun. Always a good conversation with Burning Bright. Go ahead and check out that episode for Lord of the Rings / natural law / what is Trump doing? Is he a monarch, sovereign prime type of a discussion? It was a lot of fun. This past Thursday, we had the first Gart live stream. It was extremely calm and sedated conversation about things that aren't really that important. So if you are, I'm going to get this ad read out of the way right now. If you are not going to be in person to Gart, first, you should be. The Great American Restoration Tour comes to Nashville April 9th through 12th. And you can get access to things like the live stream leading up to Gart by either getting an in-person ticket or getting a virtual ticket. I believe by the time this comes out, it's through the 15th, the early bird pricing is going on. So I think through the end of day that this show would be airing. So on Sunday, I'm recording this on late Friday night. So it would be an early bird pricing of, I don't know the early bird pricing. I know it goes back to regular pricing of $40 after that. Still not a bad deal. You get access to Telegram chat. You get access to the live streams leading up to Gart, live streams of the panels at Gart, as well as behind the scenes type stuff. Join the conversation, join the community. Come to Bart. Come to Gart. We'd love to see you for sure. And if you do come, please make sure you come up and say hi and continue the conversations that we all enjoy having. Or some people don't, I guess, but you wouldn't really be here, I guess, if you didn't. All right. I'm a little bit tired. I'm not sure exactly why. I'm on a night shift schedule, so my internal clock is all screwed up. But I've lived with that for a long time, and you just sort of make do with what you can. My wife was telling me she'd seen something about how, because she's like, I feel kind of tired today too. Really windy, and people were saying that due to low atmospheric pressure, that actually does something to affect your like how tired you feel. I don't know if that's true or not. I just know I feel more tired than I otherwise would. So if I do make some gaffes and errors, I'm just going to blame it on the wind. Last week, we wrapped up the chapter on objections to trial by jury by covering objection 5, which asserts that trial by jury is a terrible idea because it will make the law uncertain. But a simple analysis of the current system of arbitrary statute created by illegitimate legislators, which I know is redundant, proctored by illegitimate judges, also redundant, and then guided by the illusory principle of constitutionality. It's illusory because of the subjective and evolving senses in which words can be interpreted, not to mention the overwhelming breadth of ideologies that people bring to the table when reading something like the Constitution. All of that easily shows that the replacement of trial by jury is anything but certain. Spooner says, so great is this uncertainty that nearly all men, and we quoted this last week, that nearly all men, learned as well as unlearned, shun the law as their enemy instead of resorting to it for protection. They usually go into courts of justice, so-called, as only as men go into battle, when there is no alternative left for them. If you recall, he calls it a labyrinth, and the guides that we must trust and pay, that is the lawyers and the judges themselves, are often confused and inadequate to the task of guiding us safely through. Or, benefiting from the confusion, they aid and abet the twisted and entrapping nature of the legal system. I don't really like calling it a justice system, considering the fact it is the least likely place that you will find actual justice. Part of this problem stems from the insistence on the creation of written law, but language is too subjective, and even if the written could be plain and have zero ambiguity, Spooner argues that plainness and certainty are poor compensation for justice. He uses a hypothetical plain and certain law banning the drinking of water on pains of death to demonstrate his point, because clearly such a law is at face value obviously unlawful, and the fact that it is plain and certain is irrelevant to the cause of justice. And going back to the purpose of a justice system should be to find and to enforce justice. The fact that a law is plain and certain and yet violates justice, the plainness and certainness is irrelevant. And then even still, the written law must be interpreted by a higher law, which Spooner argues would be natural law. I would agree with him on that because, as he says, and some of you in the chat enjoyed this thought process he has, though the words contain the law, the words themselves are not the law. And this must always be the case because words do not create ideas, but only recall them. And the same word may recall many different ideas. As the people, we are the sole authority on what the government may or may not do, and we all inherently appeal to natural law to do so within our own minds. Spooner writes, whether therefore written laws correspond with or differ from the natural, they are to be condemned. In the first case, they are useless repetitions, introducing labor and obscurity. In the latter case, they are positive violations of men's rights. We are thus subjected to the absolute tyranny of judges, blind guides in their own labyrinth, as they arrogate themselves to tell a jury what the law is, as if any sane and normal man does not already know what the law should be. And we, the people, rather than telling the government what our rights and liberties should be, which is the way it should be, and we do that through trial by jury, we are therefore reduced to mere shadows of men and women, asking permission to live, hoping against hope that maybe in the next election we'll receive mercy from our new masters who, hiding behind the fraud that is the speech and debate clause, wield over us an absolute and irresponsible power. That is the right of property, because that is exactly how they view us. They're perpetual human tax cows that they have no problem milking until we die. If it isn't plain enough already that there is nothing about the system that we live under that resembles the slightest modicum of liberty, although we deceive ourselves into believing we have it because we can vote and because we live in a relatively luxurious slavery, then tonight's topic, the chapter on how juries of the present day are illegal, should further the case that we should view our situation truthfully and stop lying to ourselves. I'll also present what I have found, I've alluded to this a number of times, about how the illegal judges or justices subverted trial by jury in the same manner they established the false but prevailing doctrine of judicial supremacy. And in fact, the man that I would argue did the most damage as far as setting the precedent to trial by jury was also connected to judicial supremacy. It's not John Marshall, but a compatriot of his on the Supreme Court that we'll get into later. But first, we have Maha Yourself with supplements that don't suck from Conscious Strength. Founded by Badlands' very own Jordan Sather in 2019, Conscious Strength products are made in America and won't break your bank, unlike other online brands. Their lineup includes collagen for strengthening joints and hair, electrolytes to get rid of those cramps, greens powder that tastes good and mixes easy, Shilajit gummies, methylene blue, zeolite, and more. Flip the finger to pharma. Be your own doctor and get supplements that you can trust from Conscious Strength. Go to badlandsmedia.tv/strength to shop now. That's badlandsmedia.tv/strength. And the link will be in the description down below. And then next up, when did it do that? There we go. We have, new to my ad reading repertoire, the Scales Freedom Collection is where open ocean meets red, white, and blue seas we call home. Inspired by salt air, tight lines, and the rhythm of the tide and waves, this collection channels the spirit of freedom through the lens of a waterman's lifestyle. From long-sleeve performance shirts built for the elements to butter-soft tees and hats adorned with bold, ocean-inspired Americana prints, every piece is designed to keep you cool, protected, and connected to the water that sets us free. From weed lines to tree lines, we love our freedom. Shop now at badlandsmedia.tv/scales and enter the code BADLANDS at checkout for 20% off your next purchase. And on OnlyLands tonight, just a little bit ago, I noticed that Cam Cooksey was wearing one of their shirts. So I think that's rather interesting. And then last but not least, we have Tiny Bright.
Legend says, on St. Patrick's Day, a beard without oil is just a chin with ambition. But a beard with soft disclosure beard oil, that's true treasure. Spiced vanilla, naked, smooth as a leprechaun's getaway plan. Soft enough to impress your barber, bold enough to confuse a baby goat. And this boar bristle brush tames your beard like it holds the crown coin. Every bottle is American made, which means when you buy Soft Disclosure, you're supporting 6 American small businesses. That's not luck, that's capitalism with cheekbones. And while you're at it, try our mint green deodorant, because even legends need fresh pits. Soft Disclosure, go for gold. Visit softdisclosure.com and use promo code TINYBRIGHT for 15% off.
These statements have not been evaluated by the FDA. Promo code does not apply to bundle discounts.
The beard brush is apparently flying off the shelves at an unprecedented pace, and they're not in stock currently, which should tell you that when they are in stock, you need to order them because people like them. As I've mentioned, I love my beard brush, and I really enjoy the beard oil. All right. Chapter 6. The juries of present day are illegal. How can Spooner say such a thing? First, let's recap what makes a jury legal as Spooner has laid it out. Remembering, the law that makes something legal or not legal is not a law that exists in an arbitrary fashion. It is something that is codified in nature by God himself. That does not mean, by the way, that somehow these standards that you see on the screen are like baked into the fabric of reality and you can do a science experiment and suddenly you find this list. It is obtained through the process of logic, understanding what it means to be made in the image of God, what it means to own your own body, what it means to own anything, really, what it means to live in a manner in which we can be at peace with one another as fallen men and women, what it means to be at a state of war with one another, and how certain actions cross culture will lead to one or the other of those two outcomes, war or to peace. And so, starting with that framework, trial by jury is a logical outcome, respecting and honoring consent, respecting and honoring the obligation that we all have to live up to natural law, and then also to hold each other accountable to natural law. Trial by jury is the best, I would argue, attempt in human history at doing something that most honors the consent of every person involved in a political society. And so this is the legal sense in which disputes can be played out in Spooner's mind. So trial by jury, as we've seen, is 1, it's based on the natural right to resist tyranny. 2, it's 12 people are randomly selected. 3, the judges, the jury judges by their consciences. It's not by statute. We talked about criminality being about intent, not about arbitrary fiat statute. And then lastly, the jury must be unanimous. So going through these, based on natural right to resist tyranny, and this is kind of like a mini recap of a lot of the things that we've covered so far. A tyrant could be anyone that is trying to rob you, defraud you, or kill you, violate your natural rights in some way, violating your consent. Governments are typically associated with tyranny, but it is the quality of the action rather than the one doing the action that makes it tyrannical. So your neighbor that's stealing from you is technically tyrannizing you. The more technical term of tyranny would be something like codified, backed by the full weight and power of a large-scale government or something. But the quality of the action is basically the same. You're being stolen from, you're being kidnapped, you're being murdered, etc. It just happens to be a government that's doing it. So this natural right to resist tyranny, it's recognized ironically in the Second Amendment of the U.S. Constitution, as well as the acknowledgement of trial by jury. If you recall, Spooner connected those two concepts, the Second Amendment and trial by jury, as being co-equal means by which this natural right can be exercised. And I say ironically because any attempt that has ever been made to actually use the Second Amendment for its original purpose has been met with terrifying consequences. And Spooner points to the United States Civil War as the most drastic and despicable example of what lengths a government that is built on consent will go to preserve its power when people try to withhold that consent. As you recall, the South did not shoot first. The North was Han Solo in that case. This should also inform you as to why the system has been so keen in destroying trial by jury, in the same way that they have done everything they possibly can to undermine the Second Amendment. That's a little bit harder to do, I think, destroy the Second Amendment, although they have effectively made it meaningless. As you recall, the statement by Joe Biden that you would need an F-15 and nukes to fight against the U.S. government. Yeah, okay. That's just that's the situation we're in. The second point is 12 people randomly selected. So this random selection is important. And it's 12 peers. And again, a peer is not just someone who is your same race, your same measure of education, your same social status. It's your equality as it pertains to the law. If you steal, it doesn't matter if you are rich or if you are poor, the law should treat you the same. Natural law does treat you the same, whether or not that is enforced is another matter, but therefore literally anyone is your peer in this situation. The random selection removes any potential for manipulation by the government of the jury. This isn't the way it is like today. It's not where you randomly select a pool and then by the process of interrogation, essentially, you whittle down that pool until the prosecution and the defense have 12 people that they can agree on. That is a bastardization of this process. It is 12 people randomly selected, and then that's the jury. There are some caveats as far as who is eligible, but those are limited. I mentioned this a little bit later in my notes, so I'll cover that at that point. They're rather logical and commonsensical reasons why someone would not be eligible to be on a particular jury. The goal of the random selection, it's an attempt to effect trial by country. It's essentially trying to create a cross-section of the whole country. The next point is they judge by conscience, not by statute. It is therefore natural law using a person's conscience, which will most likely be the only enforceable law. This is possible because, as I've mentioned many times, the Apostle Paul writes that the law of God is written on everyone's hearts. We all inherently know that things like stealing is wrong. We all know that lying is wrong. We all know that murder is wrong, which, again, this tells you how little law would actually be governing our lives because we don't actually need a lot of laws governing our lives. The point of judging by conscience is the jury process is as much about enforcing liberty as it is preventing tyranny, with the idea that no one's life, liberty, or property, their consent over any of those things, can be taken from them apart from a judgment of their peers. Majority rule is an absolute usurpation of this, and I think it might be next week we will be going, I'm going to jump ahead again to the chapter on majority rule because Spooner has absolutely no affection for that concept, and he views trial by jury as the perfect stopgap against tyranny by the majority. Speaking of tyranny, the last one is unanimity is required. If the guy, and the principle behind this, again, considering this to be trial by country, we the people, this is effecting of, for, and by the people, and it's the way that this actually can be accomplished. If the principle is if the government cannot convince 12 people that a law should be the law, then it should not be the law. And as I mentioned just a minute ago, this should tell you immediately how few laws there would actually be that literally everyone would agree on. Everyone's going to agree that murder is wrong. Everyone's going to agree that theft is wrong. Everyone's going to agree that defrauding your neighbor is wrong. That doesn't mean they're not going to do those things because people are fallen and broken. But as far as things that can be enforced upon you or your neighbor, which you agree to, what you agree are your rights, what you agree are your prerogatives and your liberties, there would be very little infringement upon those by the government if the government is held to only enforcing a ruling by a verdict, not simply because some congressional staffers helped write some omnibus bill that created a whole bunch of new regulations that you can now lose your life, liberty, or property as a result of violating. So that is the real thing. That is trial by jury. And the purpose of recapping that is kind of like bank tellers by handling the real thing, which is funny in a fiat money system. But as far as a real printed dollar bill, you can better assess counterfeit by knowing what the real thing is. Why does Spooner say that juries in his day were illegal? And if it was bad for him in the 1850s, then how much worse is it for us today? His basic argument is that the U.S. government, following suit from its English predecessor, which had already had over 500 years, excuse me, over 500 years of illegal jury tampering under its belt, infringed on the jury by means of legislating illegal parameters on jury selection. If you recall, I made a big deal about this, that the Constitution does not actually define trial by jury. It simply recognizes it. This is important because it means that trial by jury is a self-existing phenomenon with a unique historical understanding. It's like the color blue or the color red in a rainbow. it would be absurd for Congress to pass legislation redefining the colors of the rainbow, and it would not really, I wouldn't imagine something like that would really gain traction. It is similarly absurd for Congress to pass legislation redefining trial by jury and then still call it trial by jury. Spooner writes, the term jury is a technical one derived from the common law. And when the American constitutions, because states also included this, by the way, when the American constitutions provide for trial by jury, they provide for the common law trial by jury, and not merely for any trial by jury that the government itself may chance to invent or call by that name. It is the thing, and not merely the name, that is guaranteed. Any legislation, therefore, that infringes on any essential principle of the common law in the selection of jurors is unconstitutional. At this point in his writing, he was still kind of appealing to the Constitution, although he was in the process of developing what came into fruition under the No Treason essay. So he considered it's unconstitutional, and even arguing from the Constitution itself, you could make that statement, and it would be a true statement. He goes on, and the juries selected in accordance with such legislation are, of course, illegal and their judgments void. This would be like your kid asks for Legos for their birthday, but you're kind of a cheapskate. So you buy them Magna Blocks or some other kind of knockoff, and then you try to convince your kid they're actually Legos. And they're going to know, no, these are terrible. They're not as good as the real thing. You can't just give them something else and call it the thing they asked for, because that would be lying. That's a violation of natural law. Spooner spends nearly an entire chapter describing in great detail the history of English infringements on jury selection, and I'm going to go ahead and spare you diving into that, mostly because that's not really relevant to our immediate discussion. Although it demonstrates how problematic it is when you appeal to representative government as being sufficient in obtaining consent of the people. It has only been used to subvert us long term. Spooner then highlights how in his day, the 1850s, nearly every state had created regulations that narrowed the jury pool and therefore placed illegal parameters for how juries were to be selected. This, of course, usurped the essential randomness. His basic argument, by the way, is that if a government can determine who qualifies as a juror, beyond the logical status of being a legal peer, how the jury is to conduct themselves, by what standard they may judge, then the government can and will determine whatever outcome of a trial that they want. If you recall back to the dichotomy between trial by country and trial by government, this is trial by government, not trial by jury. It's Magna Blocks, not Legos. It's essentially a trial wherein the executioner is presiding, and the executioner has a penchant for making bold examples to solidify his power. That is not a system in which you can boldly go in and obtain justice. Now, rather than go through his list of grievances for what made U.S. juries illegal in his time, I thought it would be better instead to outline the basic way in which juries are selected today, a more updated and current list, and then we can judge whether or not things have gotten better or have gotten worse. And spoiler alert, they've not gotten better. So, how are juries selected today? By way of overview, I got a list of the basic jury selection process from the American Bar Association. So this is current information put out by the American Bar Association. They point out now that juries may be between 6 and 12 people. This is contrary to what Spooner argues about 12 being the minimum. And the reason why 12 is the minimum is the goal of a jury is to take a hypothetical slice of the people. With all 12 people having to agree, you're getting an approximation of what all the country would agree to. So by reducing the size to less than 12, you are making that less and less likely. This removes the possibility of it being a true trial by country, because the idea is law flows up from us, the people. It does not flow down from the government. The second thing they point out is that unanimity is no longer the ubiquitous standard. With the caveat, there was a Supreme Court case in 2020 that overturned a ruling in the 70s. I forgot what year, I think it was 75 or something like that, wherein the unanimity was no longer required for criminal trials, but the Supreme Court restored that. So you still have to have a unanimous jury for a conviction in a criminal trial. However, there is a problem with the requirement for unanimity to acquit. The idea in original trial by jury is that if the whole jury can't agree to convict someone, the person is acquitted automatically because you haven't gotten enough people to agree that this person was guilty. Therefore, they're innocent, because our system is you're innocent, you're presumed innocent until you are proven guilty. So the concept that they have introduced of a hung jury is a huge problem here, because the lack of unanimity no longer accounts as an acquittal, which is a de facto statement that you are presumed guilty, not innocent. The American Bar Association had on this article that I read, they wrote, the old requirement that juries be unanimous is also changing. In misdemeanors and civil cases, particularly, states often provide for verdicts based on the agreement of 3/4 or 5/6 of the jurors. This, of course, is a direct assault on the very essence of what trial by jury is. That if a government cannot convince 12 people that a law should be a law, thinking that civil trials are usually adjudicating statutes that someone has violated that carries a civil penalty. You can lose your life, your liberty, or your property as a result of one of these trials. The requirement of unanimity is removing the ability for the jury to essentially nullify the law in that case. Where do they get 3/4 or 5/6? What is that number even based on? If they're going to try to claim it's some sort of statistical analysis, that's not satisfactory to me. Not that I would necessarily, if it goes against me, obviously in human nature, you wouldn't like it. But if a jury is going to rule against me and I'm going to lose my life, my liberty, or my property, it needs to be unanimous, and it needs to be at least 12 people. And again, the 12 people, it's in the unanimity. The idea behind that is that it is a good indication that if the government can't convince all 12, they would not be able to convince the entire country either. And the only thing that should bind us is something that all of us agree to, because consent is actually somewhat important. This concept stems from that law comes from us, the people, not from the government. And we, the people, necessarily must mean all of the people who will be subjected to the deprivation of our life, our liberty, and our property as a result of that law being enforced. This is a logical necessity simply from the statement judgment of peers, by the way, because going back to the concept that peers are your legal equals, which means everyone. So a judgment of peers means everyone, not just those 12 people. You are in effect saying we all as a country are judging you. And then also with the understanding that when you leave the jury box and you go back to your regular life, the way that you adjudicated in that situation will be used against you at some point. And then deeper still, a small portion of the people cannot dictate what the law will be for the whole people. And the reason why that's true is because consent matters. And we either believe that consent is sacred or we don't. And the system is set up in such a way, if you recall the quote from Spooner that I read last week, that the effect is a good indication of the design of something. And so the effect of this system has been to reduce our liberty, which tells you that was its purpose in the first case. The next way that juries are selected, as highlighted by the American Bar Association, and some of you have personal experience with this, those of you that have been on juries, jurors are subjected to voir dire. V-O-I-R-D-I-R-E. It means to speak the truth. This is an interrogation process that's designed to create as empty-headed a jury as possible. It's sold to us as trying to make it as fair as possible. We want people with, this is a reasonable argument, by the way. You don't want people who are, if you're the relative of the person, the likelihood of you being wholly impartial is pretty small. And in the original trial by jury system in the Anglo-Saxon period, the concept of impartiality was important as well. So if you were unable to be impartial, then you could be excused from being on the jury panel. If you are somehow legally, connected to the case as well, that would also be a conflict of interest that would be well within reason, within natural law, to excuse that person. The problem is the process is used to game the system by both the defense and the prosecution, and candidates are eliminated. And actually, we'll get into this a little bit later when I go through the history of how trial by jury was subverted. That the people that have any sort of technical knowledge or legal knowledge are typically excused. EC has mentioned this a number of times, that because he happened to know what ethanol was, that got him off of the case. And certainly anyone who knows about jury nullification and mentions that is going to be removed as well. Essentially, the government is given opportunity to make sure that jurors are compliant to its ends, and that's the concern that Spooner raises, that the government will use that sort of a process to stack the jury in its favor, and hey, look at this, the law was upheld. The other thing that is in this in jury selection is that prosecution and defense are both afforded a specific number of peremptory challenges without cause. The number that they're given is arbitrarily dictated by statute, of course, and this is wherein they can just say, I want that person off, and they're off. The most egregious aspect, though, is that jurors are instructed to follow the law, and this is a quote from jury instructions that are typically given to Illinois juries. So my home state here. It reads, "It is your duty to resolve this case by determining the facts based on the evidence and following the law given in the instructions." So again, this is specific to Illinois, but this would be the case in pretty much every state at this point. Such an instruction and arrogation by the courts is clear violation of the principle that juries judge by their consciences. We went over that during that chapter, that juries judge by conscience. I recommend you go back and check that out. The jury, this is also a violation of the concept that the jury is the final tribunal that a law must pass before it can be enforced as law. The principle is, of course, that we, the people, tell the government by what standard we submit to being deprived of our life, liberty, and property. One of the more significant problems with the concept of such an outcome, that is losing your life, liberty, or your property, being the result of a majority vote, either a majority of the people in a direct democracy or a majority of supposed representatives of the people, is that your life, your liberty, and your property, that is your natural rights, could not be then referred to as rights if they could just simply be taken away legitimately by a simple vote. It's not really a right if they can just vote it away. As Spooner says regarding natural rights, they are one man's claim against the whole world. And whether it is one assailant who tries by crook to take them, or be it the entire world who tries to take them, the immorality of violating those rights remains the same, whether it's by one person or by the whole world. And that man who is bold enough to stand up has the same right to resist that usurpation, regardless of what form it takes. The potential inability to resist or the likelihood of failure at resisting is irrelevant, and is therefore not an argument against his right, because that's what rights are. It's a claim against everyone. And then going back to the Science of Justice article that I've recommended and I will be going through at some point, if there isn't, this is a point that Spooner makes, if there isn't such a thing as immutable justice, that is an objective standard against which we can compare human action and human law, then we have no basis for crying foul when our neighbors, as members of the secret band of robbers and murderers by virtue of their secret ballot, wearing the skin suit of government, reach into our bank accounts and take our money and threaten us with death if we don't comply. But there is an objective thing called justice. And just because the majority happen to agree they're okay with violating that objective justice doesn't make it moral or right for them to do so. Now, going back to this usurpation of what the juries are instructed to do by following the law, it also demonstrates why representative government is a farce. The representative government argument backing the oft-quoted trope that we are a country that abides by the rule of law is that the law is binding because the people, not the whole people, but their elected representatives, decided something should be law. But even barring the reality of fraudulent elections, let's pretend that's not even true, and barring Spooner's other prescient issues with the electoral system that stand even with totally transparent elections, representatives could only potentially represent the specific people who voted for them. And that's because natural law requirements for a binding contract have the standard of universal individual consent. In other words, all people, if you recall from the No Treason essay discussions, all people who would be subject to that law must agree to it. That is what it means, government of, for, and by the people. And that is a non-negotiable if you're talking about honoring people's consent. This country was founded on the rallying cry of no taxation without representation. But from day one, this system has violated that founding principle. If you refer back to the first 10 episodes of this show for my treatment of the No Treason essay, or just read the essay for yourself, you can flesh out all the arguments that Spooner makes as to why that is a true statement. And the reason why representative government is a farce is because the laws that the representatives create, these representatives, they can't prove in court that anyone actually voted for them by virtue of the secret ballot. The elections never actually involve the whole people. And those laws, the results of people voting and putting a representative in office, they end up being used to tax people, i.e. steal from people who did not actually consent to them being the representative. So the concept of representative government is not congruent with the idea of we the people. It is not congruent with the idea of, for, and by the people. It is not congruent with no taxation without representation, because the majority of the people don't actually participate in the electoral process. So you instead have a majority of a minority of the people selecting who is going to represent them, who then pass laws that affect the lives of the people that don't participate. The opportunity for participation, you can't say that they've been afforded the opportunity and therefore they had a chance, because that is still violating, you're still violating their consent, because one of the natural law binding requirement or natural law considerations for a binding contract is that consent must be explicit. You can't infer consent. It must be explicit, and it must be universally individual. If at the end of the day, pragmatism wins out, well, we really, really need this because, what about the roads? Then we should just be honest and stop imagining ourselves as a moral and consent honoring society, and recognize that the rallying cry of the revolution is just as damning on us as it was on the British. So, how did we get corruption in the trial by jury process? The founders, most of them at least, understood that trial by jury was as Spooner has laid it out to be. In the 1700s and very early 1800s, in fact, a little bit in the mid 1800s as well, we'll talk about that in a minute, there's a number of cases wherein juries rejected the law and actually used their power to push back against tyranny. The 1850s, there was a number of cases involving the Fugitive Slave Act. But you could consider those rather, they're like the dying gasps of a collective knowledge of this practice. And I'll like I said, I'll get into that more here in a minute. Interestingly enough, the jury's prerogative to judge the law was explicitly affirmed by the first Chief Justice, John Jay, in a Supreme Court presided jury trial in 1794, Georgia v. Brailsford. Jay instructed the jury by saying, I believe I have a slide for this. It is presumed, so this is the Chief Justice of the Supreme Court in 1794. It is presumed that juries are the best judges of facts. It is, on the other hand, presumed that courts are the best judges of law. What he's quoting here is a common maxim. If you recall Spooner's thoughts on maxims, they're just made up by judges. But this is in general, even within a natural law jury situation, the justices, the judges were men learned in the law, or they should be at least, and they can provide good advice to the jury, but they're not the ones that determine the law. Jay affirms this because he goes on. But still, both objects, that is judging facts and judging law, are lawfully within your power of decision. You have nevertheless a right to take upon yourselves to judge of both and to determine the law as well as the fact in controversy. So this demonstrates Chief Justice of the Supreme Court, John Jay, understanding the practice that the Constitution had actually acknowledged, and demonstrates his understanding of the role that judges play relative to the jury, and then understanding the role that the jury can actually play. So we started off pretty well. The highest court in the land affirming the ancient practice of trial by jury. So when did the shift occur? The subversion began in earnest with a man who should live in infamy, his memory live in infamy, Justice Joseph Story on the Supreme Court. He was appointed by James Madison in 1811. James Madison is the one who drafted the 6th and 7th Amendments, if I'm remembering that correctly, that mentioned trial by jury, because the Anti-Federalists were not satisfied with the one mention it received in the body of the Constitution. So, ironically enough, the man who wrote those amendments became president and then appointed the man who destroyed trial by jury. So he became Joseph Story became a justice in 1811 until he served until his death in 1845. He was considered a close ally of John Marshall, who is notorious for his role in Marbury versus Madison and establishing the doctrine of judicial supremacy. And Joseph Story was very much on board with that entire concept because he was a strong proponent of a strong federal government and, of course, a strong judiciary. His impact on the legal system goes far beyond just his various rulings. He taught at Harvard Law, and he wrote a series of commentaries that helped shape American legal education for many decades following his death. And his thoughts on trial by jury are recorded there, as well as in his instructions that he would give to juries and in some of his opinions. So what did he think of trial by jury? Let's find out. In U.S. versus Batiste, 1835, this is considered a hallmark case in this sad degradation. He instructed the jury by saying, the jury have the power to bring in a verdict in the teeth of both law and facts, but I deny they have the right to do so. And here you have an interesting delineation that begins between the idea of power and right, because the early legal doctrine in this country was that power and right were the same thing. If you recall Spooner talking about the speech and debate clause creating absolute and irresponsible power, and then he refers to that as the right of private property. Power equals, or right necessarily equals power in the early legal mindset. And so Story is part of the movement that drove a rift between them. So he's saying, yeah, you have the power to do that, but you don't have a right to do it. It's like, who do you think you are telling us what rights we do and do not have? Last I checked, it's government of, for, and by the people, and you're a member of the government. You're our servant. But that doesn't seem to really fly very well in the face of these despots. He also wrote, it is the duty of the court to instruct the jury as to the law, and the duty of the jury to follow the law as it is laid down by the court. How is it the jury's duty? He just said so. This was actually an earlier case, U.S., I have a typo here, it's U.S. versus Gilbert in 1834, and he expresses the same sentiment, although U.S. versus Batiste is looked at more as more significant. He was more blatant in his instructions. He writes here, the jury are no more judges of the law in a capital or other criminal case than they are in a civil case. As you recall, Spooner made much over the fact that juries, if they don't have a right in a civil case, then they don't have a right in a criminal case. If they have a right in a criminal case, they must have a right in a civil case, because a civil case can turn into a criminal case. And so you can't say that the jury has the right to determine the law in a criminal case, but they don't in a civil case. Where I'm tired. I'm getting mixed up in my my description of that. They necessarily have to have rights in both. Here, he's denying they have rights in either. Moving on, U.S. versus Morris. This is also 1835. He writes, if the jury were at liberty to decide the law for themselves, then the law itself would be different in every case, and no man could know his rights. What does that sound like? Objection number 5 that we covered last week, that trial by jury would make law uncertain. In U.S. versus Porter in 1836, he wrote, the jury are bound to receive the law from the court. They're bound and apply it as given to the facts. And then here is from one of his commentaries. This is from Commentaries on the Constitution. He wrote this in 1833. He wrote, the jury are to decide the facts and the court the law, and the doctrine that the jury have a right to decide the law as well as the fact has been repeatedly denied. That reminds me of, that's been debunked. Well, how has it been debunked? It's just been debunked. There's no argument there. He writes, if the jury were at liberty to decide the law for themselves, it would be almost impossible that there should be any certainty in the administration of justice. The law would be as variable as the prejudices, the passions, and the caprices of different juries. The law would be uncertain. You can see why Spooner attacked that objection with as much fervor as he did. That was in his writing in the case from U.S. versus Batiste, and also from that same case, he wrote, the jury are no more judges of the law in a capital or other criminal case than they are in a civil case. I quoted this earlier. To allow them such power would be to overthrow the whole system of jurisprudence. He's affirming what trial by jury actually does, but he's denying that they have any right to do it. Why do you think he's denying the right that they have any right to do that? Because he'd be out of a job. And what do you notice about his claim? Is it an argument, or is it just a statement of his opinion? How does what he writes here compare to the manner in which Spooner built his case for why the jury must judge the law? Do you understand why we spent an entire episode on objection 5, that the law would be uncertain? And going back to Spooner's quote that the effects of a thing clue you in as to what its design was. The effects of Joseph Story's perspective here is that we have lost our liberty, which, given his role in judicial supremacy and given his perspective on strong central government, I would be willing to argue that he did not believe men really should have the liberties to determine what their own liberties are. The arrogance of this man is overwhelming. Consider his quote regarding the prejudices, the passions, and the caprices of different juries. Where do you suppose Joseph Story truly believed the power of government or of law actually came from? If the people are not trustworthy to judge of the law as members of a jury, then how could those same people be trusted to vote for the right representatives to then make the law? Again, the arrogance of this man is just without fathom, to quote one of my favorite animated movies, Megamind. Now, there's 4 cases that demonstrate the progression in legal sense of the subversion of trial by jury. There are other cases, but these are certainly the most significant. And let me pull this back up here. The first is, we've already mentioned, U.S. versus Batiste in 1835, and I've already read you selections from his instruction to the jury. In his commentaries as well, he doesn't make a case for why his instruction is true. He just says that it is. Kind of going back to where he says that it's been repeatedly denied. I read a certain amount of context for the statement, especially in his commentaries on the Constitution, which is where that quote repeatedly denied came from. And in the context, there's no answer to the question of why. He just says this is what it is. And then this goes back to the arbitrary authority that the judges have claimed for themselves. And it's just that. It's arbitrary. We decree. It's fiat standard. It's fiat statute. In preparing for the, I don't want to give away too much, I'll get yelled at by Ash. In preparing for the Gart trial by jury immersive experience that we are planning, I have been sort of doing some thought experiments and whatnot in creating laws. And it's incredibly easy. You just find a behavior that you don't like and you say it's illegal. It's completely arbitrary. So Spooner, or it's not Spooner, but Story, I'm so used to saying Spooner, it's like, just slips out. Story is just simply he's stating his opinion, but he did zero work. And like I said, in the context of reading around that quote, there's no explanation as to why that should be true. It just is. That's the way it is. Just like the way the mainstream narrative will say that story was debunked. Well, no, it hasn't. That's like the case. Well, there's all these cases regarding election fraud, and they all they all failed. There's a lot of nuance there. That's the way a global regime likes to just brush things under the rug. Same playbook. Should tell you it's the same overall intent to destroy your liberty. And that was a quote that I read last week regarding legislation. That's the purpose of legislation, is to destroy your liberty. The next case is U.S. versus Morris. This is different from the U.S. versus Morris that I mentioned earlier. This is from 1851. This was a situation. There was a number of cases wherein the Fugitive Slave Act was being challenged by juries, and they were effective in acquitting people and nullifying the law effectively. This is where some of the early days of the practice of voir dire really came into play, because the potential jurors were asked what their opinions were on the Fugitive Slave Act, and if they didn't like it, they were excused from service. Which shows you how the government uses that process. If you're going to rule in a manner that depletes their power, they will remove you from the jury. This is why random is important. The next one is Sparf versus United States. And if you want to read into the cases, I read a little bit into them. The nuts and bolts of the cases isn't really important. It's really the impact that those cases ended up having on the notion of juries trying the law as well. So in Sparf versus United States, it was, and these are Supreme Court cases. The juries were, it was affirmed that the juries must take the law from the judge. And Sparf versus United States is codifying the practices that were talked about by Story. He helped to frame the ideological discussion around the topic, and then because of his influence at Harvard, he also was influential in training up the next number of generations of legal minds. And so that whole effort was codified really here in Sparf versus United States, where the juries must take the law from the judge. It was ruled that judges should not inform juries that they may disregard the law. They did affirm that juries still can, but you have to already know that that is your right to do so. And then it was affirmed, judges determine law, juries judge facts. But again, there's no argument associated with it. It's just a statement, this is true. And if you recall, Spooner's problem with maxims is that judges have and justices have had hundreds and hundreds of years to invent all sorts of maxims by which they can rule over us. The last case is U.S. versus Dougherty in 1972. And this is important because it was determined that juries may still nullify. They may. But the shift was then that judges must not inform them of that power. So again, if this kind of affirms the Sparf versus United States outcomes, it has gotten to the point, though, where if you even mention that as and I've mentioned this before, if you mention that as a defense counsel, that would be a perfectly legitimate argument in a trial by jury situation, true trial by jury. You're at the defense, and you know that the guy has broken the statute, but you tell the jury, do you really want this to be a law that we are all subjected to? No, I don't. Then the person's acquitted. If you do that as a defense counsel, you will be held in contempt of court immediately. They do not mess around with that stuff. So those are the four main cases that factor into the history of trial by jury. There are other aspects of the progression. I mentioned the shift in power versus right. Like I said, the founders, for them, power implied a right. But men like Story began the separation of those two concepts. And the framing of, yeah, you have the power today, but you don't really have the right to do it. And that raises some serious questions. Who determines the rights that you have? Our founding documents say those rights come from God. But these guys here are trying to say that they're the ones who get to determine what your rights actually are. And they're not even making the effort that Spooner does in trying to build an argument. They're just saying this is the way it is. And then unfortunately, what has happened, I believe, because of codifying things like the Constitution, people, I think, got a sense of complacency in thinking that, well, I'm represented, therefore I'm safe, and they fell asleep at the wheel, so to speak. And there really wasn't, apart from, like I mentioned, like the last dying gasps of this collective knowledge in the 1850s in regards to the Fugitive Slave Act, people forgot about this practice. They forgot about this right. The conversation about what consent is, what rights are, what should be a law has largely been neglected in this country. It's certainly not going to be taught in a government-funded and proctored public education system. Because if you go back to the history of the American public education system, John Dewey is considered the father of the modern American education system. He's famous for having signed the Humanist Manifesto, and also for the Dewey Decimal System. And his belief was that the public education system should be creating good drones for the state. We need good workers. We need them to be able to do the basics, go to a job, pay their taxes, and go home. We've lost a lot, and people get upset with the friction that happens in things like the live stream on Thursday and whatever. But we're talking about life and death stuff here, and we're talking about really, really important, deep, fundamental human core truths, real first principles, elemental to nature principles. And I keep making the point, if we're going to go forward into a new golden age, it's not going to be very shiny. It's going to be a fool's golden age if we keep making the same mistake, which, if you look at our system, is that it claims to respect and honor consent. It claims to be moral, but it is not. And the subversion and just absolute obliteration of trial by jury in this country is a symptom of an overall problem that we, the people, have forgotten these things, which means we, the people, in our own individual families, need to be teaching these things to our children, teaching them to our neighbors, teaching them to our friends, to our coworkers. And that's certainly the purpose of what I'm trying to do here on this show. And I'm deeply grateful to John Harold and Badlands Media as a whole for providing me this platform to do so. And as I've said many times, I'm deeply grateful for all of you who have stuck it out with me for these number of months, hearing things, really, really uncomfortable things. As I've mentioned before, I sort of crossed the Rubicon a long time ago when I first read Spooner, and it clicked with me. I know it doesn't click with everyone immediately, and there's a lot of questions and and problems and so on that people have in their minds when it comes to these topics. But these are conversations that need to be had. I guarantee you most people aren't thinking about, and this isn't to toot my horn, this is kind of to toot all of our horn, because we're all part of this conversation right now. People just aren't having these conversations in general. The guys that I work with, they're content to just sit there and swipe on their phones and watch TikTok and shorts. And you try and talk about this stuff, and they just sort of glaze over, and it's frustrating. But it doesn't take a majority to affect change in a positive sense. A small minority that's a loud minority can effect a lot of change. So hopefully that's what we're building here. And to again plug Gart, looking ahead, the trial by jury immersive experience is going to be a fascinating social experiment, and will hopefully be able to drive a lot of these points home, because that's really what we want. Ash and I, as we talked about, it's really what we want to affect, is that people walk away from that understanding the potency of this power, understanding why it is the government has destroyed it, and being able to put an answer on the question of, what does it mean, we the people? What power did Trump really give to us? What power do we actually have? Now, in conclusion here, there's another chapter that I'm just going to go ahead and skip, because it's kind of the concepts of it are I touched on in here, and it's the illegality of judges from Spooner's perspective. A man like Joseph Story is a perfect example of what he drives at in that chapter. He doesn't make any moral arguments. He is advocating and enforcing arbitrary objective authority, and he just unlawfully, per natural law, asserts himself into the prerogative of the jury. The jury's prerogative is to judge the law, and the idea is, because if power is coming from the people judge the law. So if the Senate, this is going back to an argument that Spooner made that we covered a number of episodes ago, If the Senate is a tribunal that a law must pass to become, a bill must pass to become a law, the Congress is a tribunal that bill must pass. The executive branch is another tribunal. The judicial branch is another tribunal. There is no reason why any of those should be a tribunal that a law must pass to become enforceable. There's no reason that any of those have that's greater than a trial by jury being one of those tribunals. And I would argue, and Spooner argues, that trial by jury is the most significant of all of those, because a law is just words on a piece of paper until it's enforced. Then it becomes meaningful. Then it impacts a person's life. Then it becomes the means by which your life, your liberty, or your property is taken away from you. And if we honor consent, you consent to living under that law, or you must be able to consent to live underneath that law. Otherwise, your consent is being violated. Trial by jury provides us the ability as the people on the ground. I mentioned this comment before, that the vast majority of us will never see the inside, the halls of Congress as an elected representative. But we all have the opportunity and the chance to be on a jury. So that is one of the reasons why we have to get this back. We have to make use of what we still have, which we still thankfully have something. It'd be a lot harder to get it reinstalled altogether. I saw reports of in England, they're trying to get rid of trial by jury altogether. God help them. What we have, though, it's a shell of the former glory, but we still have the right. And then here's the kicker. Even if they made the right to nullify, even if they made that practice, nullifying a law, illegal, you still have the right. Because a right is yours against the whole world. The question is not whether you have the right. The question is, how expensive will it be to assert that right? Right now, it's not expensive. So we need to make use of it while it doesn't cost us much to exert it. All right, looking ahead to next week, I should be live. And like I said, I think I'm going to go ahead and go through the chapter on majority rule. I think it's good in context of the larger discussion. The whole voting thing seems to be a hot topic these days. So I will be diving into that next week. Thank you all so much for joining me. Hopefully I was able to be in the chat with you all, and I'll see you all next week.
Why a spoon, cousin? Why not an axe?
Because it's dull, you twit. It'll hurt more.
Thank you so much for joining us, and don't forget to hit the thumbs up on this video. And a special thank you to all of our advertising partners. Please remember to shift your dollars to support those businesses that support Badlands Media.